Hello everyone, my name is Lalit Soni and you are watching Polity This Week by Drishti IAS. In this episode, we'll be discussing some political developments which has happened in the past week. We will try to understand that how these are important for your exams point of view. So let's start. We'll be discussing 4 to 5 topics today. So let's see. Okay. Here today we'll be discussing one topic which is related to your Madarsa education. Recently, you know that in UP state, there was this state act which was there for the regulation of the madrasas in UP, and Allahabad High Court has given some verdict about it, and then it was been reviewed by the Supreme Court, and Supreme Court right now has given their observations and they have reserved the decision as of now. Okay, so we'll be talking about that. Coming to the next one, that is socialist and the secular debate. Now when we talk about this particular terms which has been used in the preamble after 42nd constitutional amendment, in the 42nd Constitutional Amendment Act, there was two terms which has been added in the preamble, that is socialist and the secular. That was giving you the idea about the nature of the state. After that, this particular, you can say, change was challenged. There were various petitioners who has said that these two words which has been used, that should be removed. Or they have given their own, you can say, reasons behind that. But Supreme Court is still looking into it. So we'll be talking about that. Okay. Then moving further. New lady justice. When we talk about this particular topic over here, recently there was this new statue which has been unveiled by the, you can say, Chief Justice of India. Okay, so we'll be talking about that. We will be seeing why it has been unveiled or what are the features which has been changed. Okay, coming to the next one, Supreme Court on the child engagement. Most of the time you will be seeing we are talking about the child marriages. But recently Supreme Court has taken this you can say step wherein they were talking about the child engagements. Okay, Bal Sagai. When we talk about this term Bal Sagai, that is very common when we talk about the hinterlands. Okay, so we will be talking about that, why this was in news. So all these topics which we will be discussing. Along with that, we will be talking about the 42nd amendment a little bit. We will be seeing that why it is called as the mini constitution in India. Okay, so let's start. There is this new batch which is being commenced or we will be commencing on the 13th of November, 3:30 p.m. at Indore Center. So if you are interested, you can go directly visit the center and get enrolled, or you can call on this number, that is 8010440440. Okay, let's move further and start our discussion. The first topic is related to Madarsa education. As I told you, Supreme Court is reviewing a judgment which has been given by the Allahabad High Court, and Allahabad High Court has said that the UP State Madarsa Board Act is there, which is basically unconstitutional. Okay, or you can say in UP we are having this Madarsa Regulation Act, which Allahabad High Court has said that this is unconstitutional. Now Supreme Court is reviewing the judgment, and Supreme Court has made some observation, and they have said that the removing the act altogether will not do any good, because right now there is this act which is actually regulating the madrasa education. If you are removing it, you are defeating the purpose. The purpose was to regulate the education in the madrasas. Okay, now if you are saying that it is unconstitutional, that will not serve any purpose. So Supreme Court has made some observation over there. The judgment will be given later. They have actually you can say reserved the judgment as of now, but here we will be seeing that what is madrasa, what are different type of madrasa, what is the funding that is they are getting. So all these things which we will be talking about today. Okay, so let's see here. Background of the case, if we talk about, so Allahabad High Court struck down the Madarsa Act in March 2024, ruling it is unconstitutional on three main grounds. Okay, they have given three main grounds. Okay, first is your secularism. High Court has stated that the act mandates the compulsory religious education, violating the principle of secularism favoring one religion. Okay, so in madrasas, obviously there are some religious education which is provided over here. Okay, when we talk about madrasa, so there are degrees which are there with respect to, you must have heard about Maulvis. Then we have you can say various degrees like Alim, Kamil, Fazil. These are the degrees which are basically given in madrasas. So when we talk about Maulvi, that is basically your 10th level. Then we have Alim, that is your 12th level. Okay, then we have Kamil. Kamil is your bachelor degree. Then Fazil, that is basically your, you can say, master's degree. So these are the degrees which are provided in the, you can say, madrasas. Now there is this practice of providing religious education based on the religious texts which are there, like Quran, Hadith, etc. So that is there. Now court has said that it is against the secularism. Okay, so that is one thing. Second thing is right to education. Now in these madrasas, when we talk about the education which is secular in nature, let's say sciences, etc., humanities, sciences, these you can say that the quality of the education which has been given over here, that is not up to mark, considering that the NCPCR is saying that the right to education that is given under Article 21A is being violated. Okay, so that is the second concern which was there in front of the Supreme Court, sorry, High Court of Allahabad. Then moving further, the conflict with the central law. Now, as I already told you that degrees in the madrasas are given, like that is Maulvi, then we have Alim, then we have Kamil, we have Fazil. Okay, so these are the degrees which are given in the madrasas. Now, these degrees does not have any kind of recognition under the UGC norms. Okay, when we talk about the University Grant Commission that is regulating the higher education and the college education in India, so they are not recognizing these particular degrees. Now ultimately, if you are going to a school, you are getting these degrees, but they are of no use under the UGC's eye. So obviously, what is the point of doing that kind of education? So that is why there is this contradiction which is there with respect to the central law and the UP's madrasa law. Okay, so considering all these things, the Allahabad High Court has said that this law is unconstitutional and has been struck down. Okay. Now coming to the next part over here. Now hearing revealed two primary questions. Now here we are talking about the Supreme Court. Supreme Court, when they were looking into the this particular case, they have come up with the two kind of questions over here. First is distinction between the religious education and the religious instructions. When we talk about the religious instruction and religious education, these are two different terms. How we will see, when we say religious instruction, that means that whatever religious instructions or there are certain things which are given over here that is compulsory to attend at the religious worship. Okay, so let's say if there is a prayer which is happening in a school, that is a religious instruction. Okay, so that is there. Then second thing is religious education. Here religious education is basically teaching about the religion. When you are teaching about Quran, when you are teaching about Hadith, these are religious educations. Okay. Now Supreme Court has to decide whether these madrasas are giving religious education or the religious instructions. Okay. So since that is one question which was in front of the you can say Supreme Court. Now if that is religious instructions, so you know that Article 28 says that if any kind of institution is being supported by the funds from the state, okay, or government is paying some kind of funds over there, so you cannot make these religious institutions compulsory over there. Okay, so that cannot be done over here. Okay, so that is one thing. When we talk about madrasas, madrasas are getting funding from state as well as from the central government. Okay, so that is one thing, they have to look into that particular question. Second is scope of the High Court ruling. If we talk about, so High Court has said that they have struck down the altogether the act. Now D.Y. Chandrachud, our Chief Justice of India, he has observed over here is that if you are removing the whole act, you are not serving any kind of purpose. If there is some kind of, you can say, drawbacks which are there in the act, you should try to resolve them and not strike down the act. Okay, so that has been seen over here. The court considered whether the High Court was correct in striking down the entire act rather than specific provisions. Chief Justice D.Y. Chandrachud suggested that the regulation could be crafted to ensure a more secular education framework without discarding the act entirely. Okay, so here they have said that you can change the provisions, make it more secular. You should not go for striking it down altogether. Okay, that is. Now moving further, if we look at the current status of madrasa education in India, so here you can see if we talk about the data or the statistics, it is as of 2018-19, India has 24,010 madrasas with 19,132 are recognized and 4,872 are unrecognized. Now when we talk about the recognized madrasas, these are fine. When we talk about these unrecognized ones, that it can be a problem. Okay, so we have to make sure that they are also regulated. Moving further, Uttar Pradesh hosts the largest share, that is 11,621 recognized madrasas. Okay, coming to the next one over here, categories. If we talk about, there are two kind of madrasas which is there. Okay, so that one is Madarsa Nizami. Nizami means that these are charitable institutions. Okay, when we talk about these charitable institutions, they do not require any kind of you can say following the educational curriculum. Okay, they have their own curriculum. Okay, because these are charitable institutions run by some kind of charity or the trust, they will be deciding their curriculum. They do not have to rely on the state's curriculum. Okay, that is one thing. Second thing is Madarsa Darse Alia. when we talk about this Madarsa Darse Alia, these are the, you can say that institutions where states monitored curriculum will be used. Okay, so these are recognized by the state Madarsa education boards and adhering to the prescribed curriculum. Okay, so these are basically, you can say, regulated, and government will be having these boards, Madarsa boards are there, and they will be giving you a curriculum which you have to follow. And when we are talking about the Darse Nizami, there is no curriculum which is prescribed by the Madarsa boards, but that will be their own curriculum. Okay, so these are the two kind of madrasas which are we having right now. Educational framework, if we talk about, so curriculum we have already seen. Okay, other than that, we have seen the degrees, that is Maulvi, then Alim, then we have the Kamil, then we have Fazil. These are the degrees which has been provided. Then moving to the next one, medium of instruction, if we talk about, so that is there in Arabic, Urdu, Persian for the charitable madrasas. And when we talk about Darse Alia, which are having this state madrasa boards which are there, okay, they can use NCERT textbook, and they have this, you can say, more focus on the secular education as well. Okay, moving further, funding, if we talk about, the primary source of funding is from the state. Okay, and there is this scheme which is there, that is SPEMM. That scheme is run by the central government. Okay, so both, you can say, state governments and the central governments are providing funding over here. You can say scheme for providing education to madrasa or minorities, that is your SPEMM. Okay, so that is about madrasa funding, that we have seen that what was the issue, why this particular thing was in news. So that is about madrasas. Now we can move little forward, and we will be seeing that these are the issues. Now what can be the way forward? Okay, so in madrasas we have seen that mostly the quality of education is not up to mark. That is one concern that has been raised by the NCPCR. Okay, they have said that quality of secular education is not up to mark. Okay, so what are the solution, what can be the way forward? So here you can see vocational training. Not only the thing is you are going for the religious educations, other than that also you have to go for the vocational training along with the secular education. Okay, we have seen that we are having these degrees like Maulvi, Amil, you can say Alim, Kamil, Fazil. When we are having these degrees over there, and we are saying that UGC is not recognizing it, then we have to go for the hands-on experience as well. Okay, at least there will be something, vocational training will be there. They will be ensuring the employability of the person who is getting degrees from the madrasa. Okay, so that is one thing. Quality standards which we have to raise. Then equitable funding. When we are talking about the funding here, implement fair funding policies that support educational quality across all institutions. Okay, then coming to the community engagement, collaborate with the community leaders and the families to prioritize holistic education. So these are certain things which we have talked about madrasas, and these are certain way forwards. Now we can move to the next part, that is basically socialist and the secular debate. Recently there was this petition which has been filed, and that petition was in news recently. Petition is saying that these words like socialist and the secular, which were added in the constitution by 42nd constitution amendment, that is unconstitutional. Okay, that should be removed. Now Supreme Court is looking into all these things, but Supreme Court has said that they are the you can say basic structure, and they cannot be removed. Okay, so let's talk about this debate. The word socialist and the secular were added to the preamble through the 42nd Constitutional Amendment Act in 1976 during the period of emergency under the Prime Minister Indira Gandhi's government. You must have heard about the Garibi Hatao. There was this slogan which was there. Okay, this Garibi Hatao. So she has this focus on the poverty elimination. Okay, so for that she has gone for the various you can say schemes, etc., and from there you can say this idea of being socialist came into picture. Now when we talk about these two words, they have been entered into the preamble later on with the 42nd Constitutional Amendment Act, but it was said that it will have a retrospective effect. A retrospective effect means that from the time when the constitution has been commenced, we will consider that India has always been secular and socialist from that particular point of time. Okay, so that was one thing that has also been challenged. But right now, if you look at the constitution, if you look at the provision of the constitution, you will realize that these elements has always been in the constitution. When we talk about the you can say DPSPs are the you can say provisions which are talking about the welfare state. These are talking about the socialist. We have the socialist DPSPs in that. Okay, we have Nehruvian DPSPs which are there. Okay, so this socialist element was there in the DPSPs. When we talk about the secular, So we have these articles like 25, 26, we have 28, 29, 30. These articles are there, and these articles are basically talking about India being secular. Okay, we are not discriminating among religions. Okay, so all these things, these elements were there, but these elements were implicit in it. They were not directly mentioned. Okay, so that is why they were implicit. But with the 42nd Constitutional Amendment Act, preamble has used these words, or you can say these words has been introduced to the preamble, making it explicit. Okay, so that was there. Now the insertion of the socialist aimed on to emphasize on the socialism as a goal and philosophy of Indian state, with focus on eradicating poverty and adopting a unique form of socialism that involved nationalization only in a specific sectors only. Okay. Now, when we talk about the socialism, if you look at the Western concept of socialism, you will be realizing that all the institutions, all the, you can say, resources will be held by the state. Okay, that will be held by the state, and there will be a common ownership. So that is basically your Western concept of socialism. But when we talk about India, India does not have that socialism. India has a socialism. There are certain specific sectors which will be controlled and owned by the, you can say, state. Okay, let's say railway, and after that atomic energy. These are certain areas which are totally dominated, or state has the monopoly over that. Okay, so that is why we are saying that the socialism that involved nationalization only in the specific sectors. Okay, so that is the new kind of model which we have of the socialism. Coming to the next one, that is inclusion of the secular, reinforce the ideas of a secular state, treating all religions equally, maintaining neutrality, and not endorsing any particular religion as the state religion. So obviously when we talk about India, India does not have a religion of the state. Okay, right now when we talk about Pakistan, Pakistan is an Islamic country. Okay, India does not have such connotations which are added to us. We are a neutral. When we talk about the religion, we are, treating all the religions equally. When we talk about the Western concept of secularism, there is a, watertight compartmentalization between the religion and the secular sphere, or you can say religion and the politics. Okay, but that is not the case in India. In India, you will have that if there is something which is going against the constitution, state will intervene over there. Okay, but we are not having a religion of our own. We are treating all the religions equally. Okay, we are not discriminating among the religion. So that is what the idea of secularism is there with respect to India. We do not have this watertight compartmentalization. We cannot say that the politics or the state cannot interfere in the religion. Wherever religion is going against a fundamental right of a person, okay, then state will intervene. Let's talk about the temple entry sector. Earlier there was a certain section of the society which were not allowed in the temples. Okay, now here we have said that there is this right to equality which is being violated. So state has said that everyone is equal and everyone is allowed to go into the temple. So now that is how our secularism is working. Okay, so now this is about the secularism and the socialism. Now let's see debate over the removing socialist and the secular words. Political imposition was there. There was this you can say certain class of people who are saying that there was this political imposition of these words. Okay, these words were added during the time of 1976 emergency. Okay, word socialist and the secular added during the 1976 emergency, seen as forcing a specific ideology. So that is one argument which is put forward. Second is original preamble. Constitution's original values of the justice, equality, liberty and fraternity were sufficient without explicitly stating these terms. Okay, when we talk about the equality, okay, when we talk about the justice, these are the idea which are related to somehow socialism only. If we are saying that the distribution of resources should be equally, that means that socialism itself. Okay, so it was said that all the religions will be treated equally. That is there in the article with respect to the, you can say, fundamental rights related to equality only. Now in preamble these words were there, that is justice, liberty, equality. So why do we need these words explicitly? That was one argument which has been put forward. Okay, now risk of misinterpretations. Now when you have actually added this, okay, now if you are saying this socialism or the socialist country, that can be misinterpreted by various people, because socialism has various types. What kind of socialism you are following? Okay, so these are certain things which are some concerns which were raised over here. Social impact, removal of the secular may raise concerns about the religious neutrality in a diverse country. Okay, Now these are certain concerns which has been put forward. When we talk about the removal of these terms, so in the Keshwanand Bharti, it was said that something which is the having form of basic structure cannot be amended. You can amend fundamental rights, you can amend the preamble is part of the constitution and it can be amended, okay, but the thing is you cannot amend the basic structure, something which is saying that this is the core philosophy of the constitution, and if it has been, you can say, entered into the constitution, you cannot remove that, okay. So that is the basic structure doctrine which was given in the Keshwanand Bharti case in 1973. The date was 24th of April 1973, okay. So this is something which we have talked about the debate. Now moving further, you will be seeing that Supreme Court's observation, what Supreme Court has said regarding this, okay. So let's see. Secularism as a core basic structure, or you can say it is the core of the basic structure, reaffirmed the secularism as the indelible integral part of the constitution's basic structure. Petitions challenging the preamble terms, the court was hearing the issue, we have already discussed that, okay. Then equality and the fraternity, the terms like equality and fraternity in the constitution highlight the secularism as a core feature. This is something which they are saying that even before explicit use of these terms, that was already there. So it was already a core feature and we made it explicit. There is nothing wrong in that, okay. Then rejection of the Western interpretation, Justice Khanna emphasized that Indian socialism promotes equality of the opportunity and equitable wealth distribution, different from the Western socialism which we have already discussed, okay. So for your reference, I have put this slide so that whatever I have said, you can go through this particular thing. Now when we talk about the Justice Khanna, one fact I would like to tell you. Justice Sanjeev Khanna, he will be the next CGI of India. He will be the 51st CGI of India from the 11th of November, because on the 10th of November, D.Y. Chandrachud's you can say term is getting over. He will be retiring and he will be the next Chief Justice, that is Justice Sanjeev Khanna, okay. Now we can move further to the next one, 42nd Constitution Amendment Act. As I told you that we will be talking about 42nd Constitution Amendment Act, because when we talk about the terms like secular and the socialist, that were added during this particular Constitution Amendment Act. Now this Constitution Amendment is, you can say, known as the mini constitution, and you will see why. These are some of the features and not all. Again, I am telling you, these are not all the features. This is just a summary, a gist of the 42nd Constitution Amendment Act. But by looking at this, you will be realizing that why we are calling it as a mini constitution. There were various changes which were made, okay. For the first time, preamble was also amended over here. So let's see, 40 articles were amended over here, modified the preamble, and 14 new articles were also added, and 2 new parts were added in this particular, you can say, amendment, okay. So the huge chunk of the constitution has been amended over here, okay. Introduced terms like socialist and secular, which we have already seen. They have limited the High Court's judicial review power, okay. So that was there. Then president was bound by the cabinet's advice. When we talk about the, you can say, advice which is given by the Council of Ministers, president has to work on the aid and advice of the Council of Ministers, and among that Council of Ministers we have this cabinet, which is the inner circle, okay. On advice of cabinet, president is bound by that, okay. This is where they have introduced that the president can send it for the reconsideration, and whatever they have sent back, president has to give assent to that particular thing, okay. So that is there. Moving further, directive principles and the duties, that when we talk about the directive principles, they were there in the original constitution, but there were certain new were added, 39A, 43A, 48A. These are the, you can say, DPSPs which were added later. This was related to the equal justice, workers' participation in the management, and the environmental protection. 48A is related to your environment, okay. Then coming to the next one, that is fundamental duties. Fundamental duties were added with the 42nd Amendment Act. Earlier, we did not have fundamental duties in the original constitutions, okay. Now that is why we are saying that the major chunk has been added over here. Fundamental duties were added on the recommendation of the Swaran Singh committee. There was this committee, Swaran Singh committee, they have made the recommendations and on which they have added the fundamental duties. Emergency and the federal control, amended Article 352, 356 to expand the central power during the emergency, moved education, forest and more to the concurrent list. One thing is that they have made changes in the 352 and 356. Okay, written advice of the cabinet will be required for the imposition of the national emergency. Now coming to the next one, that is federal control. Federal control means that there are certain you can say state subjects which were there that has been sent to the concurrent list, and concurrent list means that center can also go for making a law in that. Okay, so that was there. Moving further, tribunals, Article 323, Article 323A, Article 323B, these were added in the form of tribunals. Article 323A is related to your admin tribunals, administrative tribunals. Okay, and for other tribunals we had Article 323B. Okay, so all these things has been done in one constitutional amendment, and that is why it is called as the mini constitution. Okay, now let's move further to the next one, that is talking about the new lady justice. Okay, when we talk about the lady justice, this concept has been a Greek concept. Okay, there was these 12 titans in the Greek philosophy. One of them was Themis, and this was considered as the, you can say, goddess of wisdom, justice, etc. After that, you know that Roman Empire, there was this king, that is Augustus, and he has said that he is reigning in the name of the, you can say, goddess of justice. That was, the name was given Justitia. Justitia was the name of the goddess, which was goddess of justice, and in the name of them they are going reigning the you can say Roman Empire. Now this is where they have come up with the personification of this goddess of justice, or the Justitia, wherein she was having a balance in the hand, okay, a sword in another hand, and she is having a leg on a particular book. Okay, so that was the idea which has been, you can say that that was a personification of a Greek goddess. Okay, that idea with the colonial past, etc., or you can say our colonial legacy, we have also adopted a statue which is of Lady Justice. Okay, or the you can say Nyaya ki Murti, which is called in Hindi. Okay, now that Lady Justice was holding similar, a sword and a balance in the hand, and there is a blindfold on her eyes. Okay, recently you must have seen that we are going away from the colonial legacies. We are going away, or we are actually making changes in the colonial laws as well, and we are making other changes as well. So considering that, one change is this particular you can say coming up with the new statue of Lady Justice or Nyaya ki Murti. So basically let's see what they have made some changes over here. When we talk about this particular blindfold, that has always not been there. Okay, so there was this normal statue wherein no blindfold was that, but then there was the writer who has made a satire. He has made a satirical comment, and he has said that you can say the goddess of justice is having this blindfold on her eyes, and she cannot see the discrimination in the you can say societies. Okay, or she cannot see the corruption which is happening in the society. He has made this satirical comment by putting a blindfold on her eyes, and later on, with change in times, it was the meaning behind that has got changed, and that has been understood as a positive sign, and which is saying that she is not making, she's there is this term that is law is blind, kanun andha hai. Now this term has been used so that we can justify that the law cannot make any discrimination among the people. Okay, so that is why this blindfold came into picture, but later on now we have actually removed the blindfold as well. So let's see. Recently unveiled by the Chief Justice of India, that new Lady Justice statue which is there, which has been placed in the, you can say, Supreme Court's library. Okay, replacing the original statue. Now design features you can see. So here you can see clothes in a sari. Then we have this symbolizing Indian tradition, one thing. Second is blindfold has been removed. Eyes are open, holding a scale in one hand and the Indian Constitution in other hand. Okay, in the place of the sword, now we are having Indian Constitution. There is this you can say phrase which is generally used, and it has been said by Hobbes, that covenants without swords are nothing but words. Okay, covenants without swords are nothing but words. That means that if you are having a law which does not have power to punish, that is nothing but just words. Okay, but that is a law which is basically, punitive kind of action they are taking. They are, the objective of the law, they are defining it as a punishment. But when we talk about Indian, you can say, philosophy of justice, we are here for the reformation, we are here for the retributions. Okay, so that is there. So by removing this particular sword from the hand and putting constitution in the hand, we are signifying, or we are giving this thought behind it, that the constitution is supreme. Okay, and constitution can take care of everything. So let's see historical context. If we talk about originates from the Justitia, the Roman goddess of justice, depicted with a scale, sword, and historically a blindfold. I told you the story of the blindfold. The blindfold added during the Renaissance period and was originally a satire on the judicial corruption, but came to symbolize impartiality during the Enlightenment phase. Okay, as I told you, with the time that has changed the meaning, but earlier it was a satire on the corruption. Okay, now if you look at the old picture, this is the old picture over here. She is having a blindfold over here. Okay, and this is basically the balance which is having, she is holding in the hand. This is the sword. Okay, and looking at the attire, you will be seeing that that is an attire of you can say Roman origin. Okay, coming to the new statue, here we are having this sari. So this is an Indian traditional attire. Okay, after that you will be seeing that there is no blindfold and her eyes are open. Okay, so that is one thing. Now second, balance is still there, and in the hand there is the book, that is constitution. Okay, so that has been the change which has been made. Now when we talk about this particular statue, that has been designed by Vinod Goswami. You can remember this name because in the PCS examination etc they can ask you this name, Vinod Goswami. Okay, so I hope that is clear. Now we can move further. Now reason for the change, because we wanted to move away from the constitutional you can say colonial legacy, sorry, not constitutional but the colonial symbols etc. So that is why we have moved away from that. The sari signifies the traditional attire which we have already seen, and then open eyes represents the law's awareness of the social realities and inequalities. Okay, so law is aware of the inequalities, law is treating equals equally and unequals unequally. Okay, then replacing the sword with the constitution underscores the importance of the constitutional supremacy in India and its legal frameworks. And then the last, you can see the statue conveys that justice should be considered the diverse social fabric of India, advocating a nuanced approach to law. Okay, so we have to make sure that we are considering the inequalities also, and then we are doing the justice. Okay, so this is about it. Now we can see that what is the need of the hour in the law. There are certain urgent actions which are needed in the law. Okay, or you can say these are the problems which we have to solve. So first is the enhance the transparency and the accountability. When we are talking about the collegium systems, when we talk about the internal working of the courts, that should be made more transparent. Then second is the increasing the representation of the backward classes, SC, STs, and the religious minorities and the women. Okay, so that you have to increase because that is very less. When we talk about women, the representation is only around 15%. When we talk about the backward classes sector, that is only around some 25%. Okay, so that is one thing which we have to take care of. Then when we talk about the high courts are operating at 60 to 70% of its human resources capacity. Okay, so we can say that there is this you can say shortage of manpower, and because of which there are cases like 60 lakh cases are there as a backlog. Okay, now coming to the next part over here, you can see in the lower courts you will be seeing that there are more than 4.4 crore cases which are pending. So appointments are needed in that area as well. Okay, so these are certain issues which are there in the judiciary. Now moving further, last topic, that is Supreme Court on the child engagement. When we talk about child marriage, we have laws. When we talk about child engagement, we do not have any law. Okay, now child engagement means that you are actually deciding someone's partner, and at the age of maturity or at the age of marriage, they will go for the marriage. Okay, now again, the freedom to choose a partner you are anyway taking away. Okay, so the thing is here, when you can say when a person, or when say a boy and a girl, they are in their childhood, the parents or the, you can say, society decides for them. Okay, they take away the right to choose the partner, they take away the right for them to give a consent. Okay, so that is why this term child engagement which has been in the news. Okay, now let's see. The Supreme Court highlighted the engagement during child's minority violates their free will and the childhood freedoms. Okay, the court urged Parliament to make a law regarding child engagement and making them illegal. Okay, so that is there. Now when we talk about the issues of child marriage, we already have laws. Okay, though the Prohibition of Child Marriage Act, that is PCMA 2006, criminalizes the child marriages, it does not explicitly prohibit the child engagements. Okay, that is why Supreme Court has given direction, or they have urged the Parliament to go for making a law. Now, current situation of the child marriage in India, if we talk about, so mostly if we look at this data over here, in 1993 it was 49%. when we talk about girls, 49% of the girls has witnessed child marriage. When we talk about the 2021, that has reduced to 22%, but still you can say 22% is still high. You can say 1 of 5 girls are getting married before the age of, you can say, majority. Then moving further, if we talk about boys, it was there 7% in 2006, and that has reduced to 2% in 2021. So there is a significant development in this particular area, but that is not the concern. Concern is the marriage of girls. Okay, concern is right now that we are having this gender divided or gender gap is there. We have to make sure that that does not stays. Okay, when we talk about educating women, etc., these factors are actually impacting the child marriages, etc. Okay, if you can say girl which is basically getting married as a lesser age, that means that we are taking away her right to you can say education. Okay, so all these factors will be impacted. Now, legal measures to prevent the child marriages. So we already had this Prohibition of Child Marriage Act, PCMA 2006. It prohibits the marriage, set the legal marriage act at age at 18 for women and 21 for men, and imposes a penalty for those promoting the engagements in the child marriages. Okay, they are promoting or getting engaged in the child marriages, there is the penalty. Now the thing is, when we talk about these marriages in India, going for a child marriage is an offense. Okay, but if the marriage has been done or the marriage has been performed, that marriage is not void. That is not void. That means that that marriage will be still legal. Okay, they will have all the, you can say, rights which are there for a wife. Okay, but they are voidable marriages. If the person or the, you can say, bride or groom at the age of majority, they realize that they have been taken their right to consent, they have been taken the right to choose their partner, so within 2 years of the age of majority, they can approach the court and get these marriage a void marriage. Okay, so that is why these are voidable marriages, but not void marriage. They are automatically not void. Okay, so you can go to court within 2 years of the attending the majority, and then you can make this marriage illegal. Okay, so that is there. Other than that, recently there was this development in Uttarakhand. They have actually increased the age of you can say female from 18 to 21 for marriage. Okay, so earlier it was age which was 18 years, which was in confirmation with the law, which is central law. So they have done it 21 years now. Okay, now this is still there would be an you can say assent from the president. Okay, then moving further, Independent Thought versus Union of India 2017 case is there. Supreme Court ruled that the sexual intercourse with minor wife aged 15 to 18 would be considered as rape, raising the age of consent to 18 years. Okay, so age of consent is 18 years obviously, and if a person is there and wife is basically minor and they are going for the sexual intercourse, in that case that will be considered as rape. Okay, so that is about the child marriage and the, you can say, some provisions which are there with respect to India. When we talk about the challenges, so there are certain challenges which are there because of which child marriages are still prevalent. Okay, so that is, one is your cultural norm and the social attitudes. Okay, so here you can say there is this deep rooted cultural norm because of which people are not coming out of it and they are going for the child marriages. Legal gaps are there. When we talk about the Muslim personal laws, etc., they are there. Okay, and there, when we are talking about the tribal societies, they are still going for the child marriages. Lack of enforcement. As I told you that child marriage is illegal in India, we are having punishments, etc. But if marriage has been performed, that is, marriage is still a voidable marriage. Okay, that is not a void marriage. Then moving further, gender inequality, gender discrimination is there, and because of which you can say girls are forced to go for the early marriages. Okay, then we have social pressure and the misinformation. All these factors are responsible for the you can say these gaps in the implementation of Prevention of Child Marriage Act. Okay, so this is about child marriages. Now we are having these questions for you, so let's see. Article 28 of the Indian Constitution deals primarily with freedom of religion, freedom of speech, prohibition of religious instructions in the educational institutions, and right to constitutional remedies. Okay, so you can attempt this question and answer to me in the comment box. Moving further, what is the legal age of marriage under the Prohibition of Child Marriage Act PCMA 2006 for a woman in India? 16 years, 18 years, 21 years and 20 years. Okay. Moving further, what was the exact constitutional status of India on 26th of January 1950? A democratic republic, a sovereign democratic republic, a sovereign secular democratic republic, a sovereign socialist secular democratic republic. Okay, so you have to tell me answers of these questions in the comment box. You can attempt these questions and answer me there. Okay, with that, I would like to take your leave. I'll see you in the next episode. Till then, have a good day. Thank you.
For more informative content, like, share and subscribe, and do not forget to press the bell icon to get the notifications.